With the juvenile accused in the December 16 gangrape set to be released on Sunday, the Delhi High Court has today refused to intervene in the matter and or to issue any orders with regard to the extension of his stay. Anisha here has been following the case. Anisha, what has the court stated?
The Delhi High Court bench of the Chief Justice and Justice Jayant Nath has said that there is no legal basis to keep the juvenile incarcerated, since the Juvenile Justice Care and Protection Act of 2000 is quite clear that the maximum sentence that can be awarded to a juvenile is 3 years, which expires on 20th December 2015 for this particular juvenile. Further, the Delhi High Court has directed the Juvenile Justice Board and the Women and Child Development Department to consult with the juvenile in question and his family and officers of the department concerned to come up with a rehabilitation plan for this particular boy. And also the Delhi High Court has said that the government has to create a policy, a mechanism for the future, so that pre-release of a juvenile from incarceration, there can be some assessment of their mental state and how much have they been rehabilitated, especially since in this particular case there have been allegations that instead of being rehabilitated, this boy has in fact been radicalized by other inmates of the same special home.
So what is the next step for this juvenile?
Well, as of today, what we know is that he is set to be released on the 20th. The Juvenile Justice Board and the WCD department, that's the Women and Child Development Department, have to consult with him and his family and senior officers to create some sort of a rehabilitation plan. The plan that was already submitted previously before the court had mentioned that the Delhi government has agreed to give him 10,000 rupees as an initial aid to set up a tailoring shop so that he can have some financial assistance, so that he doesn't get into a life of crime or any that he doesn't remain as vulnerable anymore.
Okay.
For what happens now is also that the Juvenile Justice Act has provisions for monitoring, and in what can be closely termed as a probation for 2 years, that the monitoring committee can or an NGO or a juvenile welfare officer, child welfare officer can be deputed to keep monitoring this boy and for up to 2 years.
Okay.
What that is a decision that the Juvenile Justice Board has to take under the High Court orders.
Okay. And how are the parents of the victim reacting to this?
They have, in fact, the girl's mother was in the courtroom when the judgment was pronounced.
Okay.
She broke down in court again and said that, we've been fighting to keep this, for higher punishment for this boy for the last 3 years. She's made statements like, we feel that, crime has won and we have lost, justice has lost and crime has won. They're obviously understandably unhappy with the judgment. Even Subramaniam Swamy, who had filed this PIL, has said that there are still loopholes. As the court has said, that 2-year monitoring can happen.
Right.
He has said that there is hope that he will actually be properly monitored for the next 2 years.
Okay. Those are the most recent developments in this case. Thank you, Anisha.